Yeah, your lordship first time is taking the original side, but I am only here. There is an urgent matter in before court number 1. So, my lord, regarding item number 38 and 39 of your lordship's list in appellate side. If your lordship, I have already spoken with the other side, Aparna Banerjee is appearing for the respondent.
Yes.
And if your lordship kindly fix item number 38, next week after next week, because she will be not available on next week. And she will be not available today also. Item number 38.
38 and 39.
38 and 39. 38 you can fix on that day. 39 as your lordship fix.
Then in the month list of April?
As your lordship list.
Full length. 38, 39. Month list of April.
But at the top, my lord, because I have some urgency. They are not as they are
that
not.
assurance I cannot give.
Okay, as your lordship.
Before court, everybody is same.
My lord, may I permit to mention, my lord, 5 execution application, my lord.
Execution application. New.
New one.
Execution application.
Execution application, everything has been completed.
Original side.
Original side.
And what the
5 men.
Lordship may be allowed for restoration application, mentioning of a service.
appellate side or original side?
Appellate side, restoration application,
Full length.
mentioning of a service.
Any other mentioning? Call the list. এটা নিয়ে নিন তো কালকে লিস্টটা পড়ে আছে কেন? Yes.
I appeal for the respondent, madam.
No, I am saying so. Not. On behalf of Mr. Topon Mukherjee, madam, is out of station.
Topon Mukherjee কারে আছে?
7-8. Sick, madam. Sick
developer. কোন Topon Mukherjee?
Pleadings are complete, Mr. Ghosh.
My lord, yes. Pleadings, my lord. So let me, my lord. Yes, my lord. So far as I'm concerned, I find, my lord, that it has been done by us.
KMC is the answering respondent here.
Naturally, my lord, the plan has been questioned, my lord.
411 notice.
Not plan, my lord.
11.
411. And plan which was sanctioned earlier, that has been cancelled by the order of the court.
Take down.
Virtually, কথা বলতে বলেছে যদি virtually থাকে।
Virtually absent.
My lord, I appear. I was not being let in. I was as an attendee, was not being let in as a panelist. My lord, I appear for the petitioner. My lord, Mr. Odinda Banerjee is appearing. My lord, he's leading me. He's before the Supreme Court today. My lord, in a matter. My lord, kindly keeps it on any other day.
On behalf of the petitioner and
respondent.
respondent number?
Sick brothers.
Respondent number 7.
7 and 8.
On behalf of the respondent number 7 and 8, and accommodation has been paid for. Stop. Prayer for accommodation is concerned and allowed. Let the matter be listed on 21st. 28th is he will be available, Mr.
My
Banerjee.
lord, my lord.
What about you?
4th April.
4th April. He is saying 4th April.
4th April, my lord.
Let the matter be listed on April 4, 2025 under the same heading at 10:30 am.
I'm so grateful, my lord.
Yes, call the appellate side matter. কি করা যাবে আর ওই তো ওগুলো দাঁড়িয়ে আছেন নাকি Sir, give your appearance.
Appearance is for your benefit.
আপনারা একটু অ্যালার্ট থাকুন আমরা মামলায় থাকবো না ওইদিকে থাকবো Yes, call the list.
For item 29 is Lordship has directed the chairperson of the DPSC Hubli to be personally present at 10:30. Item 29, my lord.
29.
Lordship.
What was my direction?
Fixed matter, my lord. Direction was that since my lord learned no one appears for the DPSC Hubli on last occasion.
Wait for some time. Okay. 27 এর ফাইলটা একটু বার করে রাখবেন
29, my lord.
29. Yes, call the list, call the list. To be mentioned for insertion of the name, no?
My lord.
But in item 1, 5 and 6, my lord, I am for the petitioner.
2, my lord, I am for the state.
My lord, 8 and 9, I'm for the petitioner.
What is the omission, madam?
My lord, in 12th March order, my lord, Mr. Uday Shankar Chattopadhyay names was not there as appearance, my lord.
Mr. Chattopadhyay appeared on behalf of?
On behalf of, my lord, today's item number 8 and 9, Sayyid Ghulam Murtaza and
No, what is the WPA number?
WPA number, my lord, 845 of 2025 and 845 of 2025 and
2025.
Yes, my lord. And the other matter is 1436 of 2025.
1436
Of 2025. These two matters, my lord.
Right.
845. 845 or 1436.
My lord, there was another advocate's name on behalf of WPA 1436. In the order.
1436.
Yes, my lord.
Ah.
There is another name, my lord.
Provide the names.
My lord.
Ashun.
Cases Mr. Uday Shankar Chattopadhyay's names.
Oh, and
Pronoy Borshak, my
in both the matter.
Yes, my lord. In both the matters.
তাহলে লিখলাম in কি লিখলাম তাহলে এটা কিভাবে স্টার্ট করেছি Mr. Pronoy Borsar in connection with
এটা দেখে দেখ আমার নামটা আছে
আচ্ছা এইটা একটু বার করুন তো ভাই 29 কি বলছেন একবার দেখেন কি আছে একবার দেখি 29 She is from Hooghly, Chuchura.
Lordship, Lordship.
So why she has not here? He
My
or she
lord,
has
the
not come?
problem is, my lord, usually, my lord, I appear for the DPSC Hooghly in every matter.
Huh.
Now, this has not been communicated to me with regard to the order of his lordship. And
No. Notice was directly
I
sent to
know,
his
my
or
lord, notice
her
was,
office.
notice was sent to her office, but unfortunately, this was not communicated to me. So that's what, my lord, this situation was arises, my lord. Otherwise, if it is in my knowledge, my lord, then I could have come and addressed before his lordship in this matter.
Of course, Evan. Who is your other side? Mr. Prantik Ghosh.
Prantik,
Mr.
29.
Do one thing.
Lordship,
I shall take up the matter at 12 o'clock noon.
lordship,
Inform Mr. Prantik Ghosh.
lordship, lordship.
Because in his presence.
No, let the list be called on then in that event, my lord. Let her be here, my lord. Let the list, lordship, call the list, my lord. Accordingly, my lord, the matter will be taken up. When 29 comes, I will address.
Very good. No, please ask Mr. Ghosh to remain
I will
present
add-
at 12 o'clock. I shall take up the matter.
Lordship, lordship.
Item number 70.
Call the list. Item number 29 at 12 p.m. You please communicate, sir. Mr. Ghosh.
But in this matter, I am for the petition.
Notice, sir.
But they have served a order, but without giving any opportunity of hearing, without our appearance, they have passed order. 2022, your lordship passed order. And after 2025, my lord,
No. On the last occasion, a report was filed.
yes, on 18th March 2025, they have passed order
My lord, kindly
without
consider
give.
that on the earlier occasion,
Ah,
the great video.
give me a second, Mr.
Yes.
Senmukto. In compliance, an opportunity of hearing
Yes.
was provided to the petitioner. The undersigned made field visit.
The
So it was
My lord
opportunity was first.
was pleased to hear that Mr. Sengupta asked PCO to pass a reasoned order and to communicate. And
That reason order has been given.
Yes.
Passed.
given, but without giving any opportunity of hearing.
No. Yes.
2022, 22 matter was heard in the year 2022.
This is the very.
And what regarding, my lord, the unauthorized construction, there is no whispering regarding unauthorized construction.
My lord, it is in the contempt application whether my lord's order has been complied with.
Give me a second, sir. Let me.
Yes. My lord was kind enough.
Sir, Mr.
I-
Senmukto,
Sure.
please remain silent for some time.
This separate call. And video is present.
December 2022, hearing was given, but up 2025, without giving any opportunity of hearing, they have passed order.
As per my
And no whispering regarding unauthorized construction, regarding only ingress and egress.
No, that cannot be taken care of.
The entire, your
It
lordship,
has been, sir, it has been your client. What is the name of your client?
Devasi Sadok.
His signature is there.
Yes, it was communicated to advocate, learned advocate.
2022, my lord.
My lord, kindly see my
14th
lord's own order.
14th December 2022, his signature is there. But 25, no signature. He was not present.
But I should say he is misleading the honorable court in a contempt jurisdiction.
Let
আগামী
them pass it.
14ই ডিসেম্বর 2022 তারিখে বিকেল 3টের সময়
হ্যাঁ।
Yes,
নিম্ন শিক্ষা স্বাক্ষরিত কার্যালয়ের বিশেষ শুনানি হবে।
2022.
হ্যাঁ
2025, they have passed order, passed
As
order,
per my
as
lord's
per your
order.
lordship's order. And let them given any opportunity to appear at the time of passing order? And kindly have a look to my lord. Inquiry was held
It was also
in our absence.
2022. No, when the result order was passed.
18th March 2025.
My lord, as per my lord's direction, my lord, kindly may I beg one indulgence? My
And
lord, on the last
2022.
let me make humble submission. My lord, kindly consider, kindly recall. At that point of time, the video was present and also he is present now, that the hearing was made pursuant to my lord's direction,
Where is
but
my-
no reasoned order was passed.
Where is my order, sir?
Last, my lord, that is, on the last occasion, my lord passed an order.
No, no, no.
You just
Let me
Yes.
see.
Yes. Kindly see. Pass a reasoned order. And reasoned order was not passed, and even opportunity of hearing was given. That's why my lord was kind enough.
17th March.
Mr. Sengupta
No.
asked the video.
In WPA 9061 of 2019, this order was passed on 1st December 2022.
22.
What was the direction?
After treating
That
the
I have to,
entire
shall consider the
repeat-
incident as a representative of the reprisoner after giving an opportunity of hearing to the hearing of being also opportunity of being heard, and to shall pass a reasoned order within 8 weeks.
Yes.
So
That part
what
has
is
been
say?
complied with long back.
As per the Honorable High Court, a hearing notice was had to 7/12/2022.
Yes, hearing was given.
Just a
but-
minute, sir.
Sorry,
Accordingly, both the parties are 14 bar. From the report of the author, it is found that joint bill absent.
Well, 2022 opportunity of was given to the petitioner, but no order was passed. After 3 years, pursuant to your lordship's order, they have passed on 18th March 2025 without giving any opportunity of hearing. In my absence, they have passed order. And the second paragraph, petitioner remained absent, though he was communicated over telephone to remain present in inquiry, for the time of inquiry. I have no knowledge whether there is inquiry was held or not.
Take down.
Lordship's order will not be fully complied with. My submission has been recorded, only they have stated that they requested
condemned,
over telephone.
Proceed order was challenged by elaborate decisions, section 5 was rejected.
By elaborate decision?
Section 5 was rejected. Yeah, 5 was the seat.
Oh, which is why you are appearing with a smiling face. Ah. So, Mr. Siddiqui, you have no.
Comply.
You will comply.
Will comply because this order has been uploaded in the server just day before you start.
Para 16-year lawsuits can be.
But consequently, the appeal and the stay application, everything has been 16. You have the dismissal of the section.
Naturally. Also, in course of hearing,
Check.
11th, then 11th April.
11th, Friday. And if Mr. Bari is not there, he will join online.
He said. Sir,
I have filed this,
lawyer
my lord.
sub-division has got some face value, sir, to us.
Right, but that is Mr. Siddiqui submitted the for that will be.
No, I think it should be proper to fix it on 11.
11th.
Please accept it.
I'm accepting it.
But my other side is there, Deep Lordship.
Oh, yes, yeah, very good. Mr. Ghosh. So far 29 is concerned is আছে? I think 20 ওটা দিয়ে দিন।
The Lordship has directed for personal appearance of the chairperson of the DPSC in terms of his Lordship's order, my lord, she is there, clerk.
Mr. Ghosh, what happened on the last occasion?
Lord, on last occasion, Lord, my lord desired was that the respondent number 3 and 4 should be present. In their absence, the matter cannot be decided. And accordingly, Lord,
They have not filed their affidavit in opposition.
No, Lord, they have not filed their affidavit of opposition. Matter is pending since 2012. Lord, the
এই affidavit of service টা দেখি একবার বললেন affidavit of service টা কোথায় আছে বার করুন না লিখেছি তো affidavit of services filed today is taken on record. হ্যাঁ বললেন এইটা নয় আর একটা হবে মনে হচ্ছে এটা নয় এটা ছাড়া দেখি আরো আছে বোধহয় এর পরে বোধহয় ফাইল করেছেন ইয়েস এইটা ইয়েস chairman Hooghly district who is the chairman chairperson madam what is your name I beg you Shilpa Nondi. So what is the predicament in making a contact with your lawyer? অসুবিধা কি হচ্ছে আপনারা তো নোটিশ পেয়েছেন
খেয়াল করিনি ওটা আমাদের ভুল হয়ে গেছে
কি এরকম মানে বেখেয়ালি হয়ে কাজ করেন কিভাবে
হয়ে গেছে
Sir, what do you want? You want to file affidavit of
I file everything. He has said, my lord, that you want to file
Pursuant to the-
supplement affidavit, that a copy may be given to me, my lord, I will deal everything.
very good.
My lord, I appear for the response.
Petition, my lord. 11টা হয়ে গেছে না? 11টা হয়ে গেছে না? 12. Oh, it is that matter. Yes, that is matter.
Lordship, I appear for the respondents. I have a preliminary objection. There's an alternative remedy available. No whisper in the writ petition as to why the alternative remedy should not be invoked. No case made out for exception from the principle of alternative remedy. If Lordship permits, Lordship, I'll place my point.
Nothing taken in their opposition. I shall take up at the time of hearing. The affidavits are complete.
The matter is ready for hearing, Lordship. I'm ready to argue.
But this difference has not been taken in the.
It's a purely legal. It's a purely legal.
Law point, sir. Pure law point. I think there are certain numbers of judgments that, despite there being an alternative remedy, I can pursue the writ petition. My lord.
Correct. He has to meet the three exceptions.
You meet your submission. May I place the writ petition first? Give me a second, sir. Yes, yes. You are Mr. Banerjee? Yes, ma'am. Yes, place your case. Now, the petitioner is engaged in the business of manufacturing and selling of leather goods in India as well as in other international countries, my lord. But what has happened in the course of business, my lord, on 15th March or 11th March rather, 11th March 2015, my lord, one Leathercraft Wonderworld LLC of USA placed a purchase order upon the petitioner, my lord, for a sum of rupees 10,532 US dollars. To implement the aforesaid export order, my lord, the purchase order is annexed in the petition, my lord, at page 12. Messrs. Leathercraft Wonderland. Messrs. Leathercraft Wonderland LLC placed a Washington DC placed a purchase order. Yes. Amounting to 10,532 US dollars. Yes. That is paragraph 4. Yes, madam. To implement the aforesaid export order, madam, on 9 June 2015, petitioner applied in the regional office of the respondent number 1, that is the export credit for export insurance policy, and the policy was granted. The policy for export insurance, madam. If the buyer who is taking the money is not paying us, then that insurance will help the petitioner in getting back the amount. So, who is the respondent then? Is Export Credit Guarantee Corporation of Limited. And Assistant General Manager, such and such. They are the Article 12 authority? Yes, my lord. I have stated in paragraph 12, paragraph 2 of my writ petition. Company wholly owned by the Government of India and OIC, functioning as Export Risk Corporation, Insurance Corporation. The policy appears from page 15. My lord, we applied for the regional policy. Yes. Applied for regional for export regional office. I went to the regional office for export insurance policy. Export insurance policy applied. I'll not waste your. What happened thereafter, sir? I'll not waste your lordship's precious time. I will take only the relevant paragraphs or the relevant points in the policy. I will kindly come first at page 90. 19. Yes.
The first line, the policy can be of valuable assistance. This is not important. If payment for any of your shipments get blocked, delayed or lost due to the commercial and political risk mentioned in the policy, you will be able to claim a major portion of the loss from the corporation under the policy. So it says if it
payment for any of shipment
gets blocked, delayed or lost
due to commercial and political risks mentioned in the policy, you will be able to claim a major portion from the author. Yes.
This means if the buyer does not pay, I am entitled to money. If the shipment that I've sent gets lost, I'm entitled to money. Then page 22. Rather page 21 once. Page 21. Page 21. Roman 3. Action in the event of non-event of payment for any shipment. On learning of non-payment of any bill, you are required to notify the corporation of the default and simultaneously to take suitable action to prevent or minimize a loss, including such action as may be suggested by the corporation. Action to prevent minimize a loss will depend on the facts and circumstances of each case. And on the next page, page 22. Page 22, Roman 4. Filing of claims and waiting period for settlement of claims. Roman 4A. Claim under the policy has to be filed within 360 days from the due date of payment or 540 days from the expiry of the policy, whichever is earlier. The corporation will take all efforts to take a decision on the matter immediately.
360 days from the due date of payment or
540 days from the expiry of the policy, whichever is early. Then page 23. Representations, Roman 5. At the start, at the top. Representations against claims rejected or partially settled. In case a claim is rejected or is partially paid Roman 5 at the top.
Oh.
In case a claim is rejected or is partially paid for any reason, you can make 2 representations at the most. The representation should be made within 3 months from the date of receipt of communication about rejection or partial settlement of claim. Representation beyond that time will not be eligible for consideration. Now I have made they have rejected, I have made a representation. I'm just showing the relevant at the first only. Then page 25. Page 25, if you see number 8, maximum liability of ECGC under this policy.
What is page 20? It is a policy.
Yes, page 25.
Schedule 1 to policy.
Yes, schedule 1 to policy.
You are referring?
8, number 8. Maximum liability of ECGC under this policy.
1 crore.
1 crore.
So they will pay maximum amount.
Maximum 1 crore. Now my shipment value was 10,532 US dollars. In Indian rupees at that time was 6,68,000.
Give me a second.
I have mentioned in the repetition.
Shipment value
6,68,620.
6,68,000. Yes.
620.
620.
Now very well, I obtained the policy.
Equivalent to rupees
10,532 US dollars. 10,532. 10,532.
No, shipment value I am asking.
Shipment value in Indian rupees is 6,68,000.
Oh, it is in rupees.
Yes, I am saying it in rupees. I'm converting
that is why I'm a little bit. Which is equivalent to how many dollars?
10,532.
And in the Indian currency, 6,68,620. Yes. That has been stated in the writ petition.
Yes, I've stated in paragraph 7. I've said. I'm coming to that. And after that, on 23rd June 2015, the office of the respondent number 2 duly sanctioned or approved the credit limit for the petitioner for a sum of rupees 18 lakh through State Bank of India.
It is paragraph 6.
Paragraph 6. And annexure is at page 63. It clearly shows that I have got a terms of payment credit period. It is 18 lakhs.
No, through the respondent number 2. Okay, limit of that too.
I will kindly come at page 63. I'll show the document credit limit approval. We have pleasure in approving the following credit limit on the above buyer or bank in your favor, subject to the terms and conditions mentioned overlay. Now, 18 lakh on terms of payment at the bottom, on terms of payment after acceptance of documents, shipment on direct delivery. Direct delivery means open delivery system means direct delivery and shipments by air directly consigned to the buyer, but within 30 days from the date of shipment. And thereafter, on 25th.
So what is the necessity of the credit limit approval? Why it has been done?
Credit limit approval is done because I have to send the money to the transporter, the airway bill that I have to cover it from the credit limit. Bank will pay 6,68,000. That has to be paid. That is why credit limit approval was done. It has to be done. It is the terms in the policy also that has to be done through the bank. Now, thereafter, on 25th June 2015, apostate export consignment for a sum of that I have said 6,68,620 was exported to the Leathercraft Wonderland LLC of USA. My lord would kindly come at page 76 to understand that the shipment has received to the buyer. '76. The transporter is writing to the petitioner now. Dear Mr. Nondi, the shipment has left CCU on 26 June 2015 at 8:40 hours via that flight. It has reached US on approximately on 28 June 2015 via that flight 8:35 AM. And the shipment was delivered on 4th July to the customer. That is the Wonderland LLC. This is as per our system updation by our US counterpart. Thus, the buyer has received the shipment. Thereafter, on 10 July 20.
Give me a second.
Yes.
Next.
But I had missed one point. My lord had asked me why credit limit is required. Credit limit is required if I pay out of my own money, out of my own pocket. There will be no legitimacy. Whether I'm paying it or not, how will the respondent number 1, to be very frank, will understand that I have paid? I can show forged documents also. I can forge the.
It may be a fake transaction.
It will be a fake transaction. That is why I had to do that through bank, and that will be approved by the policy. Respondent number 1. That was approved by the policy. Respondent number 1, and then only credit limit was approved, and from there payment was done.
In order to avoid any fake transaction.
Yes.
So every transaction will be made through bank.
Yes. Through bank. Only one transaction has been done, 6,68,000.
That is for transporting the consignment.
For transporting the consignment, and this payment was done. Thereafter, my lord, on 10 July 2015, a petitioner duly paid para 8. I paid the premium. I said that I paid the premium on the buyer for shipment, and the premium payment receipt is at page 94.
You have paid the requisite premium on the buyer shipment. A copy of the same page
94.
It is paid to the bank, of course.
No, man, it is paid to the premium of insurance premium.
Oh, insurance.
Insurance premium paid to the
You
respondent.
will paid the requisite premium on the buyer shipment with the insurance premium.
Yes.
P94 is insurance premium. Yes.
Thereafter, my lord, I tried to collect the sale proceeds of the consigned goods from the buyer. That is the Wonderland LLC. I have wrote emails, numerous numbers of emails to the buyer for giving me back the payment, due payment. The mails are appearing at page number 95 to 108 are all emails to the Wonderland LLC.
Page number
95 to 108.
Let me see what is there in 95 to 100. Your consignment contains what?
Leather.
Leather
goods. I am in the process of manufacturing leather goods and selling it to in India also.
Processed leather or raw leather or leather item?
Leather item, man. And I've stated in paragraph 3, different kinds of leather products.
Leather product.
Yes.
Finished product.
Yes.
Selling different kinds of leather products. So they did not pay.
No, they did not pay.
Right.
Then paragraph 10. The respondent authorities advised us to appoint an overseas debt collection agent, Mr. Daniel Christian, but said debt collection agent also failed to collect the sale proceeds. And now I am showing the respondent authorities themselves.
Paragraph 10.
Yes, themselves advised us to appoint one debt collection agent. That is, he will be in USA and he will be our
He
debt
will negotiate.
He will negotiate on our behalf.
Appointed debt collection. His job is like a recovery agent.
Yes, recovery agent. And that annexure starts from page number 109.
Page 109.
Yes.
What does it say?
But he has also failed to get the money. But relevant page is page 113. See.
130.
113. 113.
113. Yes. Please, please.
First, thank you for your feedback. This is a shame to the customer like this, Leathercraft Wonderland USA, but they have no legal way to avoid to pay the said outstanding. So you must take a legal step to bound they pay the bill. Thanks once again for your good movement. All the best. My all support to get the payment from them.
This mail has been sent by whom?
Sent by us to Daniel Christian, danielchristian@mahinternational.com.
Thanks for your video. This is same to the customer like, but they have no legal way to avoid
And my lord would kindly see the designation MAH International Corporation, Daniel Christian, MSc Law. So he is a part of MAH
No,
International
he has
Corporation.
sent a mail until date. However, no payment solution could be reached.
Yes.
Our attorneys informed that your buyer will till date fully rejects any liability. I have asked for a final feedback from side of our attorneys with further advice how to proceed. Then you replied to this mail.
Yes. Now,
So it is a regret mail, Raja.
yes. Now, why suddenly Daniel Christian MAH Corporation Limited? Why? That is at page number 111. That is the document. I will place from page 109. Sorry, 109. (109) was issued by the respondent number 1. They suggest at page 111 that MAH International Corporation, name and address of debt collection agency. That part is written as page 110 and starts from 111. 110 last line, name and address of debt collection agency. 111 is starting. MAH International Corporation. That is why Daniel Christian comes into the picture. Now, as they are not
Just a minute. Yes.
We intimated the respondent number 1 that payment was not being given to us. That is why page 109 was issued by the respondent number 1. They are referring your declaration of overdue payments for the month of September 2015 on the petitioner. This is the letter. Respondent number 1 writes to us 109. They say kindly ascertain the reason for non-payment by getting the bill noted and protested through a notary and inform us the reason. Do not make further shipments to this buyer till the earlier payments are realized. So we did not naturally make any other shipment transfer. And they themselves at page 110, I say, name and address of debt collection agency. And 111 says about the name MAH International Corporation. So that is why Daniel Christian comes into the picture.
It is not your case that you on your own appointed that person.
Respondent number 1 advised us.
As per their advice, you have appointed.
We have appointed. And he also failed to get the money. He also failed to.
Then what happened?
Then
you
finally,
made a claim.
I filed a claim. I lodged a claim with the respondent number 1 on 13th May 2016.
Lodging of claim?
13th May 2016.
Lodging, give me a second.
Yes.
Lodging a claim on
13th May
1305
2016.
2016. That is lodging of claim with the respondent.
Respondent number 1.
Yes. Who is the respondent number 2 then?
Respondent number 2.
An officer of the respondent number
1.
So where is that? Where is that letter?
That is at page 125.
Page number 125.
Letter not, rather it is a claim form I have to submit. I have to submit in the form. They have a form, I have to fill it up and submit.
So it is a claim?
Yes.
Yes.
Thereafter, at page 135, that is their rejection, the impugned letter. On 27th August 2016, they reject my claim. Yes. Page 135 is the rejection letter.
Please place.
It is observed from the exports, number one. We would like to inform you that we have examined the case in the light of the documents submitted with the claim form. We regret our inability to consider the claim for payment because of the following reasons. It is observed from the export documents that the bill was sent directly to the buyer. The necessary documents regarding regularization from authorized dealer for bills sent directly to buyer not been provided to us. It is observed from the claim form at point number 23 that bank reference number and date has not been mentioned in the claim. Now,
It is observed that on the documents export the bill was sent
directly to the buyer
The
for
necessary
regularization of the bill.
documents is observed from export document that bill was sent direct to the buyer. The necessary documents regarding regulation of authorized dealer.
And they say that the bank reference number and date has not been mentioned in the claim form. Now, the bill was directly sent to the buyer because it is a system of open delivery system. I can send the bill to the buyer, and there is no mention in the policy that I cannot do so, and that I have to regularize the bill that has not been stated in the policy. That is not their case. It cannot be, because in the policy it has never been said when I am paying the premium, they have taken the advance, they have approved the credit limit. Nothing has been said that I have to regularize the bills. And it is observed that
is there any part in the is there any clause that you cannot send
No.
the bill to the
that
buyer?
is what I am saying. There is no clause.
And it is observed from the claim form that at point on the bank reference number and date has not been
Now I am saying bank reference. My lord, kindly come at page 74.
mentioned. 74.
Yes.
Hmm.
This is a part of the letter or the documents. 1 minute. I am not wait for some. The respondent number 2 sanctioned the credit limit that I showed, that 18 lakhs was sanctioned credit limit. That letter. Now 74 is a part of that letter. Page 74. That is continuing from page 63 to 75. Now page 74. 23.
Give me a second. Yes. Yes.
74 is, sorry, my lord, 74 is a part of a claim form that I have submitted. It is wrongly being annexed with the P3. I'm seeing just now.
74 is not the part of the
Credit limit letter, not the part of credit limit, but I'm just saying I do not want to make wrong submission. I have just checked now. Page 64 is the starting of the claim form. Page 64. 63, only page 63 is the credit limit letter. I'm seeing just now. There have been mishap in filing, my lord. Wrongly, this claim form is also
for shipment of
claim form for shipment, and this, that is the claim form I have filed. That claim form that is annexed at page 125 is also annexed herein. Duplicated, my lord.
Oh.
Duplicated. Now, in the claim form, they say that the bank reference number is not there. That rejection letter of 27th August, they say that the bank reference and number is not there in the claim form.
So page number 64 is also claim form.
Yes, yes. 64 to 75.
To 75, yes.
Now, my lord, kindly come to page 74. Their rejection letter says that in the clause 2, they say that the bank reference number and not given and date not given. Now, page 20, point 23. Page 74.23.
Point
23. Roman 23.
23, yes.
What is written? Kindly see, my lord. To be filled in by the bank that handle the export document. I am not filling this. Who is filling that? State Bank of India, through which credit limit was approved. State Bank of India, Topshia branch, is filling this document. What has been stated? Shipment in the last column, remarks. In the last column, remarks.
Yes.
Shipment under open delivery terms. OD means open delivery terms. Shipment under open delivery terms, payment was supposed to be realized, but it is not realized yet. So no reference and no number issued. Until and unless the payment is realized, how can a bank get the reference number of the payment or the check number of the payment or the date of the payment? How can it be done? Bank has clearly stated it cannot be given. It is filled by the bank. I am not filling it. It is written in the top, to be filled in by the bank that handled the export document. State Bank of India is filling this whole column. I am not. And my lord would kindly see the calculation also given 10,532 US dollars in the column. I am not filling it, filled by the bank, so there cannot be any discrepancy. Now, according to the, my lord, kindly remember in the policy, I have shown at page 23, I have shown clause 5 that says representations against claims rejected or partially settled. At the top, in case a claim is rejected or is partially paid for any reason, you can make 2 representations at the most. The representations should be made within 3 months from the date of receipt or communication about rejection or partial settlement of claim. Representations beyond that time limit will not be eligible for consideration. Very well. As per their own policy, after I got the rejection on 27th August 2016, by letters dated 25th July 2016, 29th May 2017, and 7th June 2017, I have made representation to the respondent authority to settle or reconsider my claim. Now, this says within 30 days of the that page 23 says.
No, with reference to page number 23, clause 5.
Within 3 months, I have to make representation. Within 3 months, it has been stated.
In case a claim is rejected or is partially paid for any reason, you can make 2 representation at the most. 2
representation, very well. I have made representation within time. That is the main.
The representation should be made within 3 months from the date of receipt of communication of rejection.
Yes, my first representation is 25 July 2016.
What is that?
I have stated in paragraph 12, and the representation starts at page 136.
So this representation says about post rejection.
Yes, you have rejected. Kindly consider. I have said this is for your information and record that we have lodged one claim for the shipment to the buyer as mentioned above, and the payment for an amount of this equivalent to rupees 6,68,820 has not been realized till date. The claim has been lodged after all efforts like appointment of debt collection agent and email communication with buyer with request, but everything failed. Accordingly, we have submitted the claim form duly filled and signed with all the relevant documents as required. Further, again, we have submitted turnover detail for the period from 7th May to 24th June as required by you. They had asked, we have submitted. This is more than 1 year. This is our request you to settle the claim as soon as possible. This is being referred to RBI by the banker.
No, it was rejected on 27/8/2016.
Yes.
And what is the time limit you saw?
This is 29th May. This is 29th May. I am showing the 2016.
Within 3 months.
Yes, my within 3 months letter is at page 138. 138, my lord will come. This is little bit jumbled up letters. Page 138 is the first representation. 25 July 2016.
Oh, then why are you showing this one? Who is the advocate on record? Page number 138 is the first
representation.
Then show that.
Yes. My application. To the Regional Director, ECGC, Kolkata. Submission of turnover for the period.
Page number 138. Representation dated
25 July 2016.
and rejected on
27th August 2016.
So prior to that.
Yes, my lord, they had asked for a document for settling one. My lord, can we come?
No. Try to understand. They have rejected your claim on 27th August.
Yes.
So you have to September, October, November. That is by 26th now, 27th November you have to submit your representation.
Yes, my lord. That has not been.
Where is that letter?
But the first
October,
representation was made.
August, September, October, November. So which one is the first?
First representation was made after rejection, that is on 29th May 2017, and my lord, 29th June that is been given, 25 July 2016 was they requested us to give a turnover period document.
Oh, what is the first? Where is the first representation that I want to?
That I showed 135, 136, sorry.
It is a belated representation.
Belated representation, but they had accepted, my lord. But moreover, there is no question. I am just showing page 138 for one thing. They had asked for turnover statement.
Wait. You are not. You yourself do not know which one is the first representation.
No,
page number 136 is the first representation.
First representation.
Dated
29th May 2017.
Then what happened?
Then again we wrote letter on 7 June 2017.
No, had they replied?
No reply.
No reply.
29 June 2017. Then again on 29 June 2017 we wrote letter.
Then you filed the writ petition.
Yes. But I am showing page 138 for one reason. 138.
Yes.
138 is a letter dated 25 July 2016 prior to the rejection. Kindly see, enclosed please find attached a turnover statement which has been certified by our bank, State Bank of India, based on the realization and records of our export payment received by them. According to your email dated 21st July 2016, the certificate has been furnished by our bank for your necessary procedure for settling one claim applied on non-payment from Wonderland, USA. Hope you will do the needful at your earliest. They have requested for a turnover statement that has to be certified by the bank. We have obtained the same and supplied to the respondent number 1. In the rejection letter 27th August 2016, there is no mention about this. There is no mention about this. They had got all the documents regarding the export documents. There cannot be any discrepancy from the first I have showed. I have not paid money from my own account. It has been done through bank. There was a credit limit approved by the respondent number 1. And in the claim form also, point 23 that I have shown, it is written in the top to be filled in by the state bank that operated export documents.
So what is their stand?
Their stand is this. On the affidavit in opposition also, they say the same thing, that the bill was sent directly to the buyer, and in the claim form, point 23, you have not mentioned the reference number and date. I cannot mention the reference number and date because the payment was not yet realized, and the said column was filled up by the State Bank of India, not by me. State Bank of India has filled up the column, and they have already stated that it is an open delivery system.
So the defense which has been the ground which has been taken in their letter of rejection is the difference in their affidavit of
in their opposition also. In their opposition also. Now in my reply, affidavit in reply, paragraph 4.
reply. Just a minute. Reply para 4. Yes.
With reference to paragraph 6 of the said affidavit, I deny each and every allegation. This is general in nature. It is denied that respondent number 2 rightly rejected the claim of the petitioner as wrongly. I say that there was no bar in forwarding the bills of the institute consignment directly to the foreign buyer. I say this. I say that the subject insurance was obtained under the open delivery system that is mentioned in the point 23 filled up by the bank, open delivery system. I say that at the time of taking advance for the insurance, no objection was raised by the respondent authorities to that effect. It is denied that there was any obligation under my part to regularize those bills as wrongfully alleged or at all. It is denied that there was no bank reference in the claim. Now, my lord, kindly turn over the page. This is on general rejection. I'll not place this. Page 5 starts from 1, 2, 3, 4, 5, 6th line from the top. 6th line. In any event, I have supplied all the documents to the State Bank of India by my letter dated 17 July 2019 as received by the bank on 19 July 2017. Sorry, 17 July 2017 it would be. This is wrongly typed. 17 July 2017 as received by the bank on 19 July 2017. Along with the aforesaid letter dated this, I had also forwarded a copy of the airway bill form SDF under appendix 1 customs certified invoice. Customs certified invoice. What more can I do? Can I forge the custom certified invoice also? Along with the shipping bill. I have complied all my obligations under the insurance agreement as well as the banking norms pertaining to the then export procedure. Pertaining to the export procedure. Now, my lord, can you come at R1? R1 starts at page 8 of the reply.
R1.
R1.
Page
8 of the reply.
What is that?
This is a letter to the bank by us. Request for export extension of payment of export under shipping bill this. Kindly note that one shipment made before under the above shipment this. Recently we have been informed by this on which we would like to request you to forward the documents of the said export for extension and reference. But I am asking for the document, required documents to supply to the
Kindly
respondent.
note that one shipment made before under above shipping bill, commercial invoice number
and provide
recently we have been informed by DPSC
and providing the bank with the legitimate documents that I had in my possession to the bank, and the bank will forward it to the respondent number 1. Kindly see page number 9, that is the airway fare bill.
So, what is page number 8?
8 is my letter to the bank attaching the documents, providing them with the documents, relevant export documents. Airway bill, the bank will not possess. I have the airway bill and I have supplied to the bank, and the bank will notify the respondent number 1.
No. We would request you to forward the documents to TFCPC for the necessary
things to do the extension and reference.
So requested the bank to forward some documents.
Yes. I will kindly see the documents that I have annexed. That is airway bill, page 9. Now, page 10 is the shipping bill. Page 11 is the invoice of $10,532. The custom certified invoice or the invoice that has been generated by the custom is starting from page 12 to page 17. My lord was asking about what are the products that will appear from page 12 to page 17.
Give me a second.
Yes.
Give me a second.
Yes.
Yes.
Page 12 to 17, I was saying custom generated invoice, my lord. Custom
Sir,
certified.
then why you approach the read code?
But the payment was to be done by the respondent number 1. In
No,
terms of
what
the quality.
fundamental right or constitutional right has been violated?
The fundamental right is, my lord,
Why you have not approached the common law forum or the other forums which are available?
but I could have done that, but I have approached the read code. Read code also has the power. My lord, I have a judgment of the Supreme Court also in Harris Marine, my lord, has been given. My lord, it can be done. It is a state government run agency, my lord, union rather.
Very good. But then why before a read code? That I intend to.
Read code, my lord, at that time it was filed with the read code. This is why, my lord, I do not have any other.
No, now you have to answer why you are before a read code. Because I find from there that there was a contract of insurance.
Yes, ma'am.
And according to you, the insurance company, the respondent authorities have failed to discharge their contractual obligations. So now, how your fundamental right or the constitutional right has been violated?
This is not a privately owned company that has given
Sir,
me
that I understand, sir. It is a fully owned government company.
Yes.
So it comes under the purview of the Article 12 authority.
Yes.
I'm not on that. But why you approach the read code? Why the read code will exercise jurisdiction?
The read code, because this is a export document that has been done, and the government company is doing this side of thing without obliging the contractual terms that has been entered with the individual, but they're violating the terms without providing us an opportunity of hearing at the first. Thereafter, as a union government owned company, can they do that? They are backing out of the export. Why would we export? This is a sole proprietorship business. of the petitioner.
A government company is not immune from the statutory provisions.
Not given.
When there are statutory provisions,
But I could say, but
we
there
fail
is
to
no
understand
bar-
why you have approached a writ court.
there
Why
is
the
no
writ
bar-
court will exercise this
There is
jurisdiction.
no bar in writ court. Now, there is a numerous number of judgments that the writ court can exercise jurisdiction in this type of cases.
Show me the judge reported decision. But prima facie is that there was a violation of the alleged contractual obligation. Now देखिए की बोलছেন কি লোক
Reported 2022 SCC online SC 509 copy. Then it's citation board. 2022 SCC online SC 509.
Yes.
Paragraph 2. The appellant is an exporter of fish and meat and oil, whereas the respondent ECGC is a government company.
Yes.
ECGC provides a range of credit risk insurance covered to exporters. Appellant paid premium for the policy which covered the buyer's failure. The coverage of this policy which the bid was for rupees 2.45 crores. Was prepared with this fishing. The vessel delivered the goods on this. The overseas buyer defaulted on payment. The appellant lodged a claim with the ECGC on 14/2/2023. ECGC rejected the appellant's claim on several levels, with the final rejection on 28/3/2050. Now, kindly come at page 25 once, para 25 once.
Hmm.
509. On application of the above principle to this policy and taking into consideration of relevant documents, this court is of the opinion that the date of loading goods onto the vessel, which commenced 1 day prior to the effective date of the policy, is not as significant as the date on which the foreign buyer failed to pay for the goods exported, which was well within the coverage period of the policy. Thus, the claim could not be dismissed simply on such basis, especially given that the date of loading the goods onto the vessel was immaterial to the purpose for which the policy was taken by the applicant. There are the para 26. It is entrenched in our jurisprudence that an ambiguous term in an insurance contract is to be construed harmoniously by reading the contract in its entirety. If after that no clarity emerges, then the term must be interpreted in favor of the insured, that is against the drafter of the policy. And my lord, lastly, 36, para 36. ECGC enjoys a significant position in the market for export credit insurance in India. In financial year 2012 to 13, the total income received by way of premiums exceeded rupees 1,000 crores, with the figures only growing ever since. It is the only government company offering such niche services and is exempt from following the trade credit insurance guidelines periodically revised by the Insurance Regulatory and Development Authority of India. To deny the appellant's claim over an incorrect interpretation of an ambiguous term, that too with delay amounting to only 1 day, goes against such duties, especially given the fact that the appellant had transacted with the respondent on several previous occasions. And this shows that the ECGC is a big company and they have significant position in the market for export credit insurance. And if the petitioner want to export,
give me a second.
I think this judgment is
Give me a second.
Not from a writ petition. I'm clearing my. This is not from a writ petition. This is an order against the NCDRs. Now, the writ petition order, I am not telling that judgment right now. I am saying I can say the citation 2004-3 SCC 553.
2004.
2004-3 Volume 3, SCC 553, ABL International Limited and another versus ECGC. Just read. Single judge order was passed by the Calcutta High Court. Then division bench rejected it. Then went up to the appeal in Supreme Court. There it was upheld again. Givings. Indicate one very important.
Give me a second, sir. Keep it. Yes. Please wait for some time. Yes. In this judgment, it has been held that the question whether a writ petition under Article 226 of the Constitution of India is maintainable to enforce a contractual obligation of the state or its instrumentalities by an aggrieved party is no more res judicata and is settled by a large number of judicial precedent pronouncements of the Supreme Court. On a given set of facts, if the state acts in an arbitrary manner, even in a matter of contract, an aggrieved party can approach the court by way of writ under Article 226 of the Constitution, and the court, depending on the facts of the state, is empowered to grant the writ. That is your answer.
And my lord, most importantly, this
and another wait.
Yes, I'm sorry.
Sir, I'm working on your case.
I apologize. My lord is very fast. My lord has already read the judgment.
A writ petition involving serious disputed questions of facts, which requires consideration of evidence which is not on record, will not normally be entertained by a court in the exercise of jurisdiction under Article 226 of the Constitution. But there is no absolute rule that in all cases involving disputed questions of fact, the parties should be relegated to a civil suit. It has been held in such and such that in a writ petition, if the facts require, oral evidence can be taken. This clearly shows that in an appropriate court, the writ court has the jurisdiction to entertain a writ petition involving a disputed question of fact, and there is no absolute bar for entertaining a writ petition, even if the same arises out of a contractual obligation and or involves some disputed questions of fact. And in this judgment, the Honorable Supreme Court has entered into a contractual matter also.
Yes.
So these two are in your support.
Yes.
I believe you have completed your argument.
One submission, my lord.
Don't
I'm not extending it. I'm only saying that it has become a precedent now because the respondent ECGC is the same here. And my lord, the honorable single judge order has been upheld by the Supreme Court. There has been no change in this ABL International Limited. And the maintainability point that my learned friend was raising goes out through this judgment. There can be nothing better than this. Or upper than this. And I submit. I conclude my section.
Let me come back after 5 minutes.
As my lord.
Yeah.
Only 5 minutes.
Yes.
You are Mr. Sarkar.
Lordship. My lord, this is a contractual dispute between a private party and the respondent numbers 1 concerning a private delivery of consignment. Now, my lord, before I proceed further, it is important to dispel certain confusions relating to invocation of writ jurisdiction. My lord, when in case of, let's say, a civil suit, one argues that the suit is not maintainable, that is very different from saying that a writ petition is not maintainable. In the traditional sense of the term, no writ petition can ever be absolutely non-maintainable because the writ jurisdiction under 226 is neither limited to an Article 12 authority nor an authority under Article 226 of the Constitution. Because Lordship will find that there are several judgments now, it is well settled that in an appropriate case, a writ petition is maintainable against a purely private party as well. The relevant question to ask when one files a writ petition and someone takes the point of maintainability, the question to ask is not against whom is a writ petition maintainable. That is not the question. The question is, when is a writ petition maintainable? It is subject matter specific, not party specific. Let us assume, Lordship, in the case of a purely private party, in case of a purely private party, if that private party is called upon to discharge a public duty, then of course a writ petition will be maintainable against that private party as well. But Lordship will find, including in the judgment cited by my learned friend, whether it is maintainable or not depends on the facts and circumstances of each case. The court would have to consider the factual matrix which apply or exist in that particular case. I humbly submit, my lord, that in the present case, the subject matter makes this writ petition not maintainable at this stage.
Can I take your lordship?
Yes.
In this case, Lordship, may I first summarize some of the principles, Lordship, before going into the merits? In this case, a private party availed of an insurance contract from my client, sent certain consignment to the US. The US buyer did not pay. He claimed insurance. If we go by the terms and provisions of the contract, there are certain legal compliances necessary. In this case, my client was constrained to reject the claim because those legal Lordship, those legal compliances were not there. There are mandatory provisions given not only in the contract itself, which my learned friend did not show, but also specified by the Reserve Bank of India under the Foreign Exchange Management Act. The procedure to make a claim has to be backed by certain procedural requirements. Those requirements were not satisfied by the petitioner, which is why we had no other alternative but to reject the claim. Now, my lord, my learned friend showed two judgments of the Honorable Supreme Court to say this is a matter where your lordship should enter into the merits of the argument. My lord, may I first deal with those judgments and then place a few judgments of the Honorable Supreme Court to show as to why my lord should not even enter into the merits of this matter, considering the facts of this matter. My lord, may I first take up the 2022 judgment which my learned friend cited? My lord,
এই বললেন এসিটা কিছুক্ষণের জন্য বন্ধ রাখবো না আর চালান ব্লোয়ারটা চালাতে বলুন Yes.
my lord, kindly take up 2022 SCC Online SC 509. This judgment was shown to your lordship to buttress the submission that the writ petition is maintainable and a factual inquiry is called for. My lord, I humbly submit this judgment helps our case and answers the initial query which my lord raised. Why do you not file a civil suit or any other proceeding? Now, lordship will kindly take up the first paragraph of the judgment. My lord, may I place the fact? With consent of counsel for the parties, the appeal was heard finally. The appellant is aggrieved by an order of the National Consumer Disputes Redressal Commission dismissing its complaint. The issue urged by the appellant is whether the NCDRC was correct in placing reliance on guidelines issued by the Directorate General of Foreign Trade to interpret the date of dispatch shipment in the single buyer exposure policy of the respondent and thereby deny the appellant's claim.
So it is not out of an writ proceeding.
Lordship.
Either under Article 32 or under Article
Lordship. So my learned friend submitted that the facts of this case are similar to ours, because in this case also there was a rejection of an insurance claim by the same party. Now, lordship will see what did the aggrieved party Lordship will see what did the aggrieved party in this case do. When the insurance claim was rejected, did the party come and file a writ petition before the Honorable High Court or a writ petition before the Honorable Supreme Court? No. The aggrieved party, who is similarly situated as my learned friend's client, went and approached the consumer forum, which is a forum equally efficacious alternative remedy available to my petitioner, to the petitioner, which was available to the party there. They availed of the alternative remedy.
Then approach Supreme Court.
Lordship. Now, they did not just avail the alternative remedy. They exhausted their alternative remedy and filed a statutory appeal before the Supreme Court, which is provided for in the Consumer Protection Act. Therefore, Lordship, this case, if anything, helps my case to say that the writ petitioner should have approached his other alternative remedy. Now, Lordship, before I place ABL International, which was cited by my learned friend, now, my lord, ABL International was pronounced in 2004. It operates as an exception to certain settled writ principles, such as when will the writ court interfere in writ jurisdiction despite there being an alternative remedy? Usually, writ petition is not maintainable if there are disputed questions of fact. What are the exceptions to it when a writ petition can be entertained despite there being disputed questions of fact? ABL International operates as a settled law to the exceptions of the general self-imposed bar of alternative remedy. Now, my lord, this judgment was pronounced in 2004. Several judgments thereafter have further interpreted ABL International, have clarified ABL International, and have furthered the law in the field.
Yes.
Now, my lord, this all resulted in a judgment of the Honorable Supreme Court my lord, this evolution in the law, it continued till Lordship, a judgment of the Honorable Supreme Court in the matter of Joshi Technologies in 2015 by Honorable Justice Nariman, as his Lordship then was. ABL in Joshi Technologies, all these judgments relating to contractual field, and when a writ court will interfere into the contractual field, all the judgments, including ABL International, were considered in detail, and thereafter the law was settled. There was a restatement of the law in 2015. Now, may I place that judgment, Lordship? My lord, this is reported in 2015 7 SCC 728.
Yes.
Now, my lord will find first, if Lordship kindly comes to internal page 9, which is at top of the page, page 9, Lordship will see the page numbers are given.
Page number of yours?
Of the report, Lordship will find at the top the page numbers are given.
728.
Lordship, at the top of internal page number, Lordship, of the
Page 1.
Lordship. Lordship will see page 9, page 736.
Yes.
Lordship will see the chronological list of cases cited. Serial number 7.
ABL International.
Lordship. Lordship will see that it has been considered in extenso. Now, Lordship will kindly come to the law which was finally laid down after considering ABL International and several other judgments. Lordship will kindly come to para 69 at 766. My lord, before that, Lordship kindly comes to page 765, para 68.
Yes.
Lordship will see ABL International being cited. This is in the part, the judgment portion.
Yes.
The court thereafter summarized the legal position in the following manner. Then ABL International is quoted. And para 28 of ABL International is quoted, which Lordship may I kindly place.
Yes.
However, while entertaining an objection as to maintainability of a writ petition under Article 226, the court should bear in mind that the power to issue prerogative writ is plenary in nature and is not limited by any other provision of the
I'm sorry,
Constitution.
you are reading which paragraph?
paragraph 28 of ABL, which is quoted in para 68, bottom of the page.
Please read from paragraph 68, please.
The court thereafter summarized the legal position in the following manner.
Yes.
Lordship, this is quotation from ABL.
Para 27.
Lordship, from the above discussion of ours, the following legal principles emerge as to the maintainability of a writ petition. In an appropriate case, not in every case, appropriate case, a writ petition as against a state or an instrumentality of state arising out of contractual obligation is maintainable. B, merely because some disputed questions of fact arise for consideration, same cannot be a ground to refuse to entertain a writ petition in all cases as a matter of rule. And C, Lordship, a writ petition involving a consequential relief of monetary claim is also maintainable. In this case, Lordship, it's not a case of consequential relief. The only relief is money claim.
Yes.
Now, Lordship, may I place para 28? However, while entertaining an objection as to the maintainability of a writ petition under Article 226 of the Constitution of India, the court should bear in mind the fact that the power to issue prerogative writs under 226 of the Constitution is plenary in nature and is not limited by any other provisions of the Constitution. Now, Lordship, I place my emphasis on this. The High Court, having regard to the facts of the case, has a discretion to entertain or not to entertain a writ petition. The court has imposed upon itself certain restrictions in the exercise of this power. My lord, Whirlpool is cited, which is, I think, 1998, volume 8, SSC, page 1. It's in paragraphs 15, 16, 17. Lordship will see that the three exceptions were laid down. This plenary right of the High Court to issue a prerogative writ will normally not be exercised by the court to the exclusion of other available remedies unless such action of the state or its instrumentality is arbitrary and unreasonable so as to violate the constitutional mandate of Article 14 or for other valid and legitimate reasons for which the court thinks it's necessary to exercise the said jurisdiction. I do not find from the grounds of the writ petition, Lordship, any point relating to Article 14. Now, Lordship will see para 69. Now, after having considered ABL International and all the judgments on contractual field, kindly see what the court holds. The position thus summarized in the aforesaid principles has to be understood in the context of discussion that preceded, which we have pointed out above. As per this, well, I'll continue placing.
Please proceed.
As per this, no doubt, there is no absolute bar to the maintainability of the writ petition even in contractual matters or where there are disputed questions of fact or even when monetary claim is raised. At the same time, discretion lies with the High Court, which under certain circumstances it can refuse to exercise. It also follows that under the following circumstances, now Lordship, kindly consider this. It follows that under the following circumstances, normally the court would not exercise such a discretion. So how, Lordship, this discretion to entertain or not to entertain is to be used? The parameters are being laid down. Now kindly consider, Lordship, the sub-paras under 69. 69.1. The court may not examine the issue unless the action has some public law character attached to it. Well, now my question is, I can understand there being a contract. Let us assume, Lordship, there is a contract between a private party and the state to provide supplies to hospitals, public hospitals. That contract would have a public law character attached to it. If the contract concerns anything to do with a public utility or a public duty, then there is a public law character attached to it.
But in the event the court finds arbitrariness in the action of the respondent state, what will happen?
Lordship, the arbitrariness would, before Lordship proceeds to consider the fact of arbitrariness, my Lord would first have to consider whether there is a public law character attached to it, because the question of arbitrariness, unreasonableness, Lordship knows that this flows from a decision in England in Wensbury Corporation. Wensbury, which I believe is a 1947 case, in Wensbury, this principle of unreasonableness was evolved, and it's been the consistent position in India after that. These considerations apply only to cases having a public law character attached to it.
Right.
If, Lordship, the dispute is purely private, nothing to do with public law, in that case, Lordship, the writ court will hesitate to even consider the issue of unreasonableness or arbitrariness, because those are public law principles.
Right.
I admit, Lordship, that whenever it's a state entity, Lordship will automatically assume there is something to do with public law. But that by itself does not lend it with public law character. Public law character has to be some element. My Lord, that's been explained in this judgment.
Let us see, sir.
Lordship. Now, Lordship will see 69.2, which I will place emphasis on. Whenever a particular mode of settlement of dispute is provided in the contract, the High Court would refuse to exercise its discretion under 226 and relegate the party to the said mode of settlement. Now, Lordship, kindly note, particularly when settlement of disputes is to be resorted to through the means of arbitration. Now, Lordship, may I pause here for a moment and show one clause from the contract between the petitioner and the respondent number 1, which was not placed by my learned friend. Lordship will kindly see page 60 of the writ petition.
Yes.
Lordship will see arbitration clause 33. If any dispute or difference arises out of or in relation to this policy between the parties, such dispute/difference shall be referred to a sole arbitrator to be appointed by ECGC in writing. Arbitration shall be conducted under and in accordance with the provisions of the Arbitration and Contract Conciliation Act 1996. The venue of arbitration shall be Mumbai. Now, Lordship will read this clause with the law as laid down by the Honorable Supreme Court in paragraph 69.2 of Joshi Technologies, which was delivered after considering ABL International.
They have not resorted to the arbitration.
Never, not a whisper. This was always available to them. Now, Lordship, may I be fair to point out, Lordship will see that in the arbitration clause, it says that it will be referred to sole arbitrator to be appointed by ECGC. Now, Lordship knows in subsequent judgments in Perkins, Eastman and BSNL, etc., the Honorable Supreme Court has held that you cannot have an unilateral appointment of arbitrator. So, if there is any contract, arbitration clause in a contract which provides for unilateral appointment, then that unilateral appointment can no longer be made, but one would have to file an application under section 11 of the Arbitration Conciliation Act before this Honorable Court for appointment of an arbitrator. But the arbitration clause remains valid, remains subsisting, and in any case, Lordship, this has been there from 2018. That was the time when they should have invoked.
I got you.
Lordship, now may I come back to the judgment in Joshi Technologies?
Yes.
Now, Lordship, kindly consider 69.3. If there are very serious disputed questions of fact which are of complex nature and require oral evidence for their determination. So therefore, if there are serious, my lord, ABL International also made the distinction. A normal disputed question of fact and a serious disputed question of fact. Now, in this case, Lordship, going by the submissions of my learned friend, the dispute is regarding the mode which was followed while availing of the claim. The respondent number 1 was constrained to reject the claim because certain legal compliances had not been made, including those under the RBI circular for FEMA compliance. Now, what has happened, Lordship? When
that point has been taken by everyone in opposition.
Lordship, in fact, that is the ground in page 135 of the writ petition, that it had to be sent directly to the it was sent directly to the buyer and not routed through the bank. That is the point which has been taken by them. I will place the RBI circular in course, Lordship, which says that you have to route it through bank. The contract says that when you do an open delivery, you send it directly, but you can send it only after obtaining RBI clearance, because these are compliances required for monitoring under PMLA, FEMA, and all such other laws where money is going in and out of the country and where there can be a question of money laundering, etc. These are checks and balances, which is why they should have approached the authority, obtained the clearance, route it through the bank, and only then send it to the buyer. This entire stage was given a go by. Lordship will in fact see the declaration form for FEMA compliance. The most important conditions or the blanks have not been filled. Name of bank, details not filled up. And that is there in the writ petition itself. So therefore, now I heard my learned friends say that they had indeed approached the bank. They have submitted documents to the bank. But Lordship, we had to receive that information from the bank as to whether they had complied with these requirements at that juncture. Otherwise, it is the respondent number 1 which will expose itself to monitoring under the finance laws, FEMA.
What prevented you to get these documents from the bank or ask them to provide those?
My lord, now the question, Lordship, is I have certain procedures. There is a contract in place. The contract says that it is the petitioner's responsibility to obtain a clearance from the RBI and thereafter proceed. My lord, how is it possible for me, kindly envisage the situation, to find out whether the clearance is there? I'm an entity dealing with hundreds and thousands of such cases on a daily basis, which is why the contract puts the onus on the petitioner. The person availing of the insurance policy has to obtain the clearances, not the respondent number 1. The respondent number 1 has, as per the contract, as per RBI circular, certain forms, certain compliances. When a claim comes, it will open the relevant documents and see whether all compliance is made. If compliance is made, I process the claim. If compliance is not made, I do not process the claim. These are obligations which I do not have to point out to a private party who is exporting goods to another country. They are not a rustic litigant, Lordship, who will require some degree of hand-holding. I am an entity giving loans for credit to a private party for a private transaction, not a public transaction, a private transaction. He is selling goods for his own private business. Therefore, you are supposed to come with me with all the compliances. I am supposed to process the claim. I have seen that your compliances are not there. I have rejected your claim. I was constrained to reject your claim. Now, Lordship, this question which your Lordship raised, could the respondent number 1 itself have done this? Itself has asked the bank. Now, I can't ask RBI. I am not supposed to ask the bank. These are questions, Lordship, which would require taking of oral evidence as to what did my officers do, what did the sole proprietorship business do, what were the discussions which took place between the two parties, which can only be done through means of an arbitration. This is, Lordship, not a monetary claim of an exceptional circumstance. Lordship will see para 69.4 of Joshi Technologies. Money claims are not to be gone into writ unless they are of exceptional circumstance. This is a simple case of someone exporting a leather good, not getting a claim. All such questions of fact which are disputed, I say it's my client's instructions that you were required to do certain things which you did not. They say, no, I had asked this person, I had asked that person. Now, who is to decide the issue of fact in this case? I can understand, Lordship, a situation where my Lord decides to interfere where all facts are undisputed. Everything is undisputed, no dispute.
No,
Lordship.
Counsel, what I am on,
Lordship.
that when before repudiating this claim,
Lordship.
have you made any correspondence with the petitioner regarding the shortcomings of their documents? That I intend to know.
Lordship, this is a specific beyond what is there in the documents. Lordship,
Let us see where is the impugned letter? Page number 135.
Page 135. Lordship.
Yes, what I'm on,
Lordship.
before issuing this letter, have you made any correspondence that on perusal of the claim form such and such as not there, you please provide those? Have you made those?
My lord, that was not.
You straightway rejected their claim.
Lordship, now in this case, what has happened is this rejection is followed by, is preceded by exchange of documents where the two parties have to interact.
Have those
Lordship,
been annexed and
Lordship,
in opposition?
Lordship, it's there in the writ petition itself. In those cases, Lordship, they were
page
asked.
Number 125 is the claim form.
Lordship.
And page number 135 is the letter under challenge.
Lordship.
What I'm on,
My
that
lord.
you have stated, rather you have argued on the point of that there is an arbitration clause that there is there, absolutely.
Lordship.
But according to you, in order to settle the claim, you have to abide by some legal formalities.
Lordship.
As framed by the Reserve Bank of India.
And also in the contract. And also in the
contract. As also in the contract.
Lordship.
What I am on, prior to repudiating their claim, that is prior to issuing the letter dated 27/8/2016,
My lord.
have you made any correspondence with them regarding the shortcomings of the documents which are not available in the claim form? That I want to know.
Lordship, I will try and satisfy my lord on this. Lordship will kindly grant me.
If you can show that you made endeavor,
Lordship,
to require those documents,
Lordship,
and it has not been followed,
Lordship,
I can understand. But
Lordship,
if it is found that in the that there no correspondence has been made,
Lordship,
then your action can be called as an arbitrary.
My lord, in my lord will kindly see page 112 of the writ petition.
Page number 112.
This precedes the repudiation of claim. Lordship will kindly see print date 15/9/2015.
Yes.
But we have this is a letter written by ECGC of India Limited through the authorized signatory. Now, Lordship will see it's addressed to the petitioner, and Lordship will see Leathercraft Wonderland LLC. This is the entity to which the petitioner had supplied goods, and this is the entity which did not make payment, which is why they lodged the claim. Now, Lordship will see the letter. We regret to inform you that the limit approved on the above buyer stands cancelled with immediate effect for the following reason. Now, Lordship will see the reason. It's given in Hindi and then the English translation is given. One of our policy holders has reported non-payment by the above buyer. Therefore, commercial risks are not covered on the buyer, and premium as applicable to political risks need to be remitted. Corporation's liability is attracted for political risks only on such shipments. Now, what happened?
Only one thing to interject. I'm not interjecting his argument. This is a letter of 15 September 2015. I placed this letter. This starts from 109, not from 112. 109, page 1 of 4. My lord, you can find at the bottom. Not to get the fact all confused, I'm only correcting the same. Page number 109, the letter starts. At the bottom, it is written page 1 of 4. My lord, you see the fourth number page is at 112, the learned friend is citing.
Yes.
This is that they say that the.
My lord, my learned friend should have placed this when he was placing his case. When he chose to suppress it.
Very good.
Place. My lord, can keep the notes.
Very good. As I said, don't make wrong submissions.
Now, my lord, I will come to that. I was placing 112 first for a particular reason. My lord, Lordship will see the reason. One of our policy holders has reported non-payment by the above buyer. Therefore, commercial risks are not covered. Buyer and premium as because this is applicable to political risks only. Corporation's liability is attractive for political risks only on such shipments. Now, so I had to cancel the limit, and I duly intimated this to the petitioner. So, Lordship's first question. Lordship. So this here comes, Lordship.
So it is a caution.
It's the first hurdle. Now
it's a caution.
Yes, but I have intimated them prior to reputation of any claim, prior to making of any claim also, right at the inception.
So try to understand my question.
Lordship.
Probably you have not understood my question. Admittedly, policy has been taken.
Lordship.
Shipments have been sent.
Lordship.
Consignment has been sent.
Lordship.
He was asking for the bill. Bill was not paid. As per your advice, one MAH International Corporation was appointed.
Lordship.
And ultimately, for some reason or other, they didn't get payment. They lodged a claim, and ultimately their claim was repudiated, which is the cause of action for
Lordship.
So far, this one I believe I am clear.
Lordship.
Sir, my question was very clear. That in course of your argument, you have stated that there were latches on the part of the writ petitioner to comply with certain legal formalities like mandatory RBI guideline. That you have stated now.
Lordship.
What I asked you that in between lodging of, after lodging of claim,
Lordship.
And before repudiating his claim,
Lordship.
Have you made any correspondence seeking those documents that for processing your claim, I need these documents that I intend to.
My lord, as far as I am instructed, the petitioner had approached the ECGC. There were several meetings between the parties where it was communicated. But
your instruction will not suffice purpose.
my lord,
Have you
that is
taken
why
that point your
lordship,
giving a
but
position that I intend to see.
no, my lord, base after they approached, it is only then did we advise them to take certain steps and file the claim form where it was explained as to these are the compliances you have to do. If you can't give these documents, we will be unable to process your claim, which is why this claim form was given to them. The claim form was explained to them. They filed the claim form and thereafter it proceeded. Now, lordship, from what I can gather, what's troubling my lord is, let us assume my instructions are that without my client making them aware of these deficiencies, the claim form could not even have been filed because they wouldn't get it. When the claim form is given, it is explained to the policy holder that these are the requirements which you must comply with. If you can't, we will simply have to reject. Knowing fully well they supplied a defective claim form which was incomplete and therefore we had to reject it. Now, lordship will kindly consider this aspect of arbitrariness.
Sir, you are an Article 12 authority, sir.
Lordship.
You are not Mr. Like an XYZ company. You have discharged some public duty as you said.
Lordship, that is what I was submitting in the facts of this case. There was no public duty.
Suppose a private company employs an employee.
Lordship.
Suppose a private company employs an employee, and then a government company or the state employs an employee. There is a distinction. The latter is a model employer.
Lordship,
you being a statutory body.
Lordship.
You have some.
My lord, may I please answer the question in this way? I am a statutory body, which is why I am governed by certain statutory responsibilities. By not making let us assume
I respect your duties, I respect your obligation. But what prevented you to make correspondence with regard to their alleged shortcomings? That I interpret.
Lordship.
So that they cannot argue that yes, there was arbitrariness.
My lord, even then, I most respectfully submit it would be unheard of in law if the petitioner would be allowed to argue that they could have asked me, because they did not ask me, action is arbitrary.
Now, my last question on this point,
Lordship.
whether have you taken this point in your affidavit? No, sir, don't jump. Very unfair.
I'm not sounding, I'm just stating.
No, I don't require your assistance. Take your seat. Sir, have you taken any point in this regard on your affidavit?
My lord, I will place the relevant.
That puts that into.
My lord, my affidavit in opposition is on the part of violation of the RBI Master Circular, and that is all. That is all that I stated.
Prevented you to let
my lord,
know.
My lord,
show me the affidavit in opposition.
Lordship. Kindly see paragraph 6 at page 5.
Paragraph 6.
Lordship.
Yes. Kindly place, sir.
With reference to the allegations contained in para 11 of the said petition, it is denied and disputed that the respondent number 2 rejected the claim of the petition on flimsy ground as alleged or at all. It is submitted that the respondent number 2 has rightly rejected the claim as the bills of the petitioner were sent directly to the foreign buyer and documents regarding regularization of bills were not provided by the petitioner to the respondents. It is also submitted that in the claim form being annexed 8 to the said petition, there is no mention of any bank reference number. The petitioner had acted in violation of RBI Master Circular on exports, and by reason thereof, the claim of the petitioner was rejected by the respondent.
So this is a new point.
My lord?
Up to without mentioning of reference number, that is there.
Lordship.
That was there.
Lordship.
The petitioner had acted in violation of Reserve Bank of India Master Circular on export of such and such. The claim was rejected by the such and such. So this is a new point. It was not communicated to them.
My lord, My lord, when they enter into the contract, they have to sign a declaration that they will abide by this. My contract is based on this. How can they say this is a new point? They are required to adhere to this as per the contract itself.
But again, you have some obligation to the
My lord-
society. You are an Article 12 authority.
My lord, may I?
Then the question of principle of natural justice
My lord,
arises.
my lord, in my most respectful submission, it should not arise. But however, if my lord kindly
Sir,
indicates,
if I pass,
lordship,
don't think that I've framed my mind. In the meantime, I've probably achieved a very bad reputation that I'm a talkative, rather I'm a
no, lordship,
very talkative judge rather.
no, lordship, it's a good thing. Lordship is expressing lordship.
Yes, so that you can answer to my
lordship. Grateful.
So what I'm on, sir, suppose after hearing both of you, I passed a judgment, hard considered and rejected. Hard considered allowed. Would it be proper? There must be two W's at least. Why and what?
Lordship.
There must be what and why.
My lord.
You must know why you have won the case.
Lordship.
Or you have why you have lost the case. And what are the reasons for that?
Lordship.
So what I'm on, just so far the first part is concerned, those are there. So I'm to check whether those are in the policy or not.
Lordship.
But so far this portion is concerned that the petitioner had acted in violation of the Reserve Bank of Master Circular on exports of goods and services, and by reason there the claim of the petitioner was rejected by such and such. Sir, why is that averment in your letter? You ought to have given an opportunity to them.
Lordship. What is this master circular do, lordship? The master circular puts certain requirements. One is this direct remittance, and two is mentioning of the bank reference number. These are the two mandates created by the master circular. These two mandates are incorporated in the contract. Now, these are the two things which the master circular says they are incorporated in the contract and the claim form. Now, lordship will kindly read 135 now. It is observed from the export documents that the bill was sent directly to the buyer. The necessary documents regarding regularization from authorized dealer for bills sent directly to the buyer not been provided to us. This is only the master circular as incorporated in the contract. I will place the clause of the contract. So it is not a simplicity or dismissal that your claim is considered and rejected, as my lord gave an example. How rejected, why rejected, both are given. Page 15. Happy with the annex those. So where are so why did you disclose it?
Yes.
So therefore, lordship, these 2 points, when I say violation of master circular, I mean these 2 points which are incorporated in the contract and known to them from inception. Now, lordship will kindly see why I say this. Lordship kindly comes to page 15 of the writ petition.
1-5.
1-5, lord. Form number 144, annexure P2.
Yes.
This is the first page of the first thing that they're supposed to do. Lordship will see the instructions.
Page 1-5 is the page 1-5 is the policy.
The contract, the first page of the policy, the very first page. The contract is appended to this.
Yes.
Lordship will see that the petitioner's name is given there. Now, what is the instruction? Lordship will see. Fill in all columns of the application legibly, or if possible, send in typewritten. 2. Attach, wherever possible, a bank receipt in original copy bank certified to your application. 3. Mention the name and address of the buyer bank in the caption with with reference number and write separate letter in respect of each of your overseas buyer in all your future correspondence concerning the credit limit applications. 4. Terms of payment means DPCAD DA open delivery. Please specify the terms of payment with period clearly. 5. Now kindly consider this, Lordship. In case you are making shipments directly to the buyer, please ensure necessary approvals from the RBI/authorized dealers.
Yes.
Then kindly see page 40.
Yes.
Points to remember. Lordship will see written in big font, bold. Kindly see point number 5. Obtain credit limit on DA terms for bills consigned directly to buyer and ensure approval of authorized dealer Reserve Bank of India as required under FEMA. I informed them from the inception, from day one. Now, Lordship, I completely bow down to your Lordship when your Lordship says that when I find a deficiency, I inform them that I have found this deficiency. What do you have to say? My Lord, this would apply as a compliance with natural justice if the deficiency is not known to them beforehand. In a case, Lordship, where before, when you are signing the contract, you are informed. In the course of the contract, you are informed. When at the stage of filing your claim, you are informed and you are given that form, claim form, which contains these requirements. After 3-tier information, you fail to provide it. Well, I would like to know from my learned friend, under which possible principle of law is any further requirement of compliance with natural justice necessary? Where is the respond number 1's legal obligation? Lordship has raised a very valid question. My learned friend will have to satisfy under which law was he entitled to be informed for a 4th time that this is what you need to comply with. So therefore, that question should not arise at all as to whether he was informed or not. One is, Lordship, compliance with natural justice.
I got your point.
Grateful, Lordship. Now, Lordship, my learned junior points out very rightly. Lordship will kindly see page 46. Lordship will kindly see page 46. B. Lordship will see obligations of the insured.
His client.
Lordship, this is my learned friend's client. Now, Lordship will turn the page kindly and consider clause 8 at page 47. Now, kindly consider 8B.
Yes.
8B. A declaration of overdue payments in the prescribed form, giving information on all such shipments as were insured under this policy and in respect of which the payment due from buyer remained wholly or partly unpaid after having become overdue for not less than 30 days as at the close of the preceding month, and shall continue to deliver such declaration of overdue payments so long as any such payment remained outstanding. No such declaration. Lordship will see page 55. So when I say that you sent it directly without routing it, If you had routed it, these were the documents you would have needed. Now kindly see, Lordship, page 55 of the contract.
Exclusion clause.
Lordship, these are exclusions to my liability. And no one can shirk away from it unless, of course, the contractual term is challenged. No term of this contract has been challenged before your Lordship. It's been accepted because they're relying on this. Clause 19. Notwithstanding anything to the contrary stated elsewhere in this policy, unless otherwise agreed to by ECGC in writing, ECGC shall cease to have any liability in respect of the gross invoice value of any shipment or part thereof. B, Lordship, in respect of which the insured has failed to submit the relevant declaration of overdue payments as required in strict compliance with the requirements under condition 8B of the policy. You know this from the day you sign the contract.
No, if we come to page number 135,
Lordship.
it is observed that from the export documents that bill was sent directly to the buyer. Very
Lordship.
good. The necessary documents regarding regularization from the authorized dealer for bills sent directly to buyer not been provided to us.
Lordship,
So where is that clause? That I want.
Lordship, the necessary documents which are required are these under the contract. The petitioner knows because it is there in the form itself. What are these necessary documents? Page 10 of the AO. Only from the writ petition.
No, sir. So far clause 8 is concerned,
Lordship.
it does not relate with point number 1 of page number 135. It does not match.
My lord, if my lord is of the view, I will not proceed with that point.
It does not match.
Lordship.
Because this is a monthly declaration of shipments and overdue payments.
Lordship.
Overdue payments. Overdue payments have been informed, which is why you have advised them to employ.
Lordship, there has to be a declaration which was not given.
No, that is not. No, there is no such. There is no such.
Lordship, I will not press that point.
Sir, how much time will it require?
Lordship.
Then come back on Monday.
Lordship,
because I could have make it in the second half, but I have a division bench with Justice Bossart, and then I am to take up the commercial execution case in original settlement.
Could it be on Tuesday, Lordship?
Tuesday.
On Monday, I've only.
Very good.
My lord, I will, if Lordship kindly keeps it in the morning, I will take not a second more than 15 to 20 minutes.
Very good. I should take the.
But may I give a judgment that arbitration that has been said that
No, it will be. You make it ready.
No, my lord, my learned friend should have shown this at the.
No, I have.
In the meantime, you said.
and gives me an advance copy of the judgment, my lord, then I'll be able to consider it.
Give him a copy. Yes, yes.
My lord, before my lord rises, my lord, item number 16, both sides are present. There was a direction upon the respondent to file an affidavit. Yesterday only I have received the affidavit. I need some time to prefer an affidavit in reply. My lord, my lord.
ফাইলটা দেখি যেন both side আছে বলছি 16টা দেখি So exception to the supplementary debit is ready.
Exception is ready. I need some time to prefer a reply.
On behalf of the Above division bench is Justice Bosak, only one matter there. One or two matters are there. Thereafter, I'll come back and take up original side, I'm sorry, commercial execution cases.
My lord, I am for the judgment letter in this
I
matter.
appear for the degree holder. My lord.
But I appear for the judgment letter. My lord, this matter on 26th of September 2024.
Give me a second. This is first time appearing before this court. Give me a second. Oh, then why it has been? They are not paying the installments.
They had only paid 4,000 rupees, 4 lakhs rupees out of 6 installments which they had committed to pay. Well,
No, they are supposed to pay 43 lakhs and odd in 6 equal installments.
equal
That has not been done.
That has not been done, my lord.
How much time you require?
But only one thing. My client business is totally ruined, and he is on the score of settling all his properties which are lying in Odisha. Last night, after checking the list, I have called him and I have also messaged him. He said that he is in Odisha for settling all the properties so that the dues can be paid. There are certain other dues are also there, but kindly adjourn it for a fortnight so that
Lordship, it was his undertaking,
it was his
and
honor. I'm not disputing.
then the 6 installments were to be completed by 31st of March.
Yes, ma'am.
31st of March. The 31st of March is approaching, and in fact, nothing has been paid. What has been paid is only.
No, what is your instruction to your client?
My instruction to my client. My instruction to
Yes.
my client is to pay the amount, if it is possible, for a single payment.
Very good. Then what is
thereafter-
reply to that?
Thereafter, he could not pay. He could not pay, save and except the
So
first.
how he proposes to pay?
Now he has no business at all. He is trying to sell off the properties, ancestral properties, which are lying in Odisha. He's from Odisha basically, and from that he will liquidate all the dues.
Can I,
So
may I submit?
no,
Mother,
he has,
on
he
the
has
last
paid
occasion.
this substantial amount. He has paid this substantial
No,
amount.
no. His total outstanding was
Oh, only
53
10 lakhs have been paid.
10 lakhs has been paid. Subsequently, only 4 lakhs have been paid. So the present outstanding is, my lord, 39 lakhs
Has
61,000.
he filed his affidavit of asset?
Yes, affidavit of assets has been filed.
He has been examined.
He has been examined in part, and he on the doc has undertaken to pay this amount in 6 installments.
How many times he has been examined?
Only once.
Only once, my lord.
Only once.
Only once he was.
Let him come and face the
But
examination.
kindly make it adjourned for a fortnight.
Very good. It is submitted on behalf of the judgment debtor.
is coming up for the second time,
Lordship, this is my
if your lordship kindly takes up the last order, because your lordship had directed the decree holder to take certain steps by injuncting two properties and also two bank accounts.
But I appear for the judgment deed.
Give me a second, let me go
my
through my,
application is.
let me go through my previous order, just a minute, sir.
ठीक है चलिए ठीक है thank you.
Affidavit of
ठीक है,
service,
thank you. How much?
bank account.
पिटिशन का तो होगा much ज्यादा that's convenient much convenient.
Now, if your lordship kindly comes to page 3 of the order, paragraph 13, 14 and 15, we have complied.
So injunction has been granted in respect of two immovable property.
Yes, madam.
And further injunction was granted in respect of
Two bank accounts.
two bank accounts lying at Lake Town and
Central Bank. Yes, and Sripun.
Manager was directed to forward a statement showing the current balance of the ATO to the advocate on record.
Yes.
From today, is directed to furnish the first of direction holo. You got the bank account?
Yes, may I hand up?
Lordship, I have filed an application for
Just
intervention.
let me just
It is appearing today.
show the
Yeah, let us do the main petition first.
No, I have to.
What do I do with you?
To show your lordship only one thing, that if we see the bank accounts,
copy the
তোমাদেরই bank account.
handing over to the court আমাদের হোক কি জানি হোক ভাই
Yes. If your lordship kindly sees the two bank accounts,
ঠিক আছে
Yes.
in each of the bank accounts, a balance in less of rupees 5,000 is there.
নামটা লিখে number I appear for the judgment deed.
I have only one more submission.
বলো না sure.
So, my lord, the bank account.
Why in two papers? There are two different
different bank accounts, my lord, in different banks.
Just a minute. Account number হচ্ছে এইটা
Central Bank of India.
233.
Yes. Central Bank
the
of
amount
India.
outstanding balance is 4,644.
Yes, my lord. As far as the
Another
Punjab
is
Bank, 4,000. And the other one, my lord, Punjab National Bank, 5,890.
Wherefore I'll get the account number.
No, it is at the top left hand side.
Account number is there. 1513, na?
Yes.
The current account I find.
Yes, that is what it appears.
But it does not matches with the account number which has been mentioned in the page, in the paragraph number 14.
No, that is Central Bank of India.
No, sir, I am talking about PNB.
Paragraph 9.
Is
the current account. Oh, I'm sorry. Current account number 5844 and this is a
Central.
Both are current account. One is
No, my lord, it's current account.
Account number হচ্ছে এইটা একটা
No. So far the Indian Bank, Central Bank is concerned, well, it's the name of Nilkanto Shah that I find.
Yes.
I পরেরটা দেখি হোক না কি আছে
So 123 rupees is there.
That is what it appears.
123 and another is 5892.
Yes.
Yes.
Now, Millard.
Now, Millard, one humble submission. So, Millard, it appears that for satisfying this particular decretal amount, which is Millard 14,65,000, along with interest, which is adding on every day, Millard.
14,65,000.
Yes, and there is interest, Millard, because the decree also talks about Millard payment of additional interest. Now, Millard, the bank accounts which we have been able to find out doesn't have sufficient balance. So, your lordship, Millard, was pleased, based on the apprehension, to injunct, Millard, two properties.
Now we have, my lord, caused service of the application to the decree holder, the judgment debtor, and we have filed the affidavit of service. Lord, Mr. Mitrul, and senior advocate, is now appearing on behalf of.
My lord.
Today, my prayer would be, my lord, for filing for direction on the judgment debtor to file the affidavit of assets so that he can be examined on the next occasion.
Now, my lord, I say, I appear for Nilkanto Shah, who is the judgment debtor. There is a decree I find in against me. Now, today I am in the executing court. This honorable court has passed the decree. The executing court first will have to see whether this court has the jurisdiction to entertain the execution application or not. Lordship has passed an order on the first day in our absence. I raised the point that this execution application is not maintainable before this honorable court. Second, this honorable court.
Have you filed any substantive applications, sir?
No, because it was served, I was appointed yesterday only. I just make my submissions. If required, I will definitely do this. Whether this court, whether this first is whether this execution application is maintainable before this honorable court, number one. Number two, whether this honorable court, exercising its ordinary original civil jurisdiction, can injunct, pass order of injunction on a property outside the territorial jurisdiction. These properties, I am a resident of Sribhumi, beyond the territorial jurisdiction of the honorable court. The properties which my lord has injuncted, the bank accounts are in Sribhumi. The immovable properties which my lord has injuncted.
To say file an application. I shall.
So whether
I shall give them an opportunity of filing.
Definitely. So whether my lord has the sorry, my lord, whether this honorable court can exercise jurisdiction or can pass any order of injunction, anything on properties in an execution proceeding, immovable properties beyond its territorial jurisdiction. I respectfully submit, my lord, the answer is no. The answer is no. So I have to come up with an application for dismissal that I will have to, because I have been briefed maybe not even 72 hours back. So I could not make these things ready. And even my client is sick. What I understand, I even undertake to file the Vokalatnama because one of the not filed. She will undertake the Vokalatnama. One of the family members is in court, but my client is not in court. Because the family member being in court may not suffice in that way. But she will undertake to file Vokalatnama by Monday or Tuesday maximum.
What you say?
I am appearing for the intervener, Lordship.
Well, before Lordship takes up the intervening application, as far as the
GACOM.
I want to move my application.
Yes, yes. Milord, as far as the execution petition is concerned, Milord, I would beseech your Lordship to, Milord, kindly consider granting prayer G of the cabinet.
That you have said. Don't repeat, sir.
Yes.
Prayer G.
Prayer G. Affidavit of assets.
My Vokalatnama has been filed.
This court has no jurisdiction. That has to be decided first. That has to be first. Whether this court can.
What you said? What you said?
Yes. Lordship, my application, this is my application. My case is there. These the properties which have been injuncted, Lordship, out of that property, one property belongs to me. Lordship will find in my application, page 6, Lordship, in the annexure, I've annexed the order, Lordship, of 14 February 2025. Lordship will find in the second page, it is stated in paragraph 5.
Just let me see what injunction order I have passed.
Yes, yes. Decree holder has come to learn that 2 bank accounts and 2 different banks.
Sir. Now, tell me what is your contention.
Yes, my contention is
Page number.
Page number 6, Lordship, that is Lordship, your Lordship's order, page 2, internal page 2.
You are referring GACOM 125?
I am referring to the order which I have annexed, annexure A. Page 5 onwards, the order starts, Lordship. Your Lordship's order, 14 February 2025.
Yes.
Application, Lordship. There it is stated that the decree holder has come to know that the judgment debtor is the owner of these properties. But
Sir,
you
understand
understand,
what is your
my
case?
contention is that I have annexed my gift deed. Nilkanta Shah, the judgment debtor, had parted with the property in 2002, Lordship, to his wife.
Mongola Shah.
Mongola Shah. And Mongola Shah has gifted me in
Mongola
November.
Shah, just a minute. Mongola Shah is the donor.
Mongola Shah is the donor.
And
he
Lata
became-
Shah, who is she?
Mongola Shah, Lordship,
Is the donee.
wife of Nilkanta Shah, and this particular gift first deed, that is from the judgment debtor, had occurred in 2002. The Lordship will find that.
Sir, try to understand my question. Try to.
Yes.
So far as annexure B is concerned, that is a gift deed executed by between whom?
By Mongola Shah and my client, that is Lata Shah.
Very good.
That is the intervener before your Lordship.
Let me see the schedule of the deed.
Yes, please, Lordship.
What is that?
Schedule is Lordship will find.
It's 90.
Second schedule, page 20.
Page 18 or page 20?
20, internal page 11. Second schedule.
Second schedule is the property which has been
that
gifted.
is portion of that property which has been injuncted.
Acha.
This now belongs to my
No,
client.
schedule, see, first schedule is the entire property.
First is the entire property.
Let me see what is the first schedule.
First schedule is the entire property.
What is the holding number? Premises number is 161 by 1 Dokindari Road, Calcutta 48.
Yes, 16.
Municipal premises number 160 by 1 Dokindari Road.
Yes, yes, yes.
Have you got it?
Yes, 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 Lord.
Your brief, sir.
Yes, Lord. No, no, actually my Xerox is this condition.
Oh.
That is the problem.
And out of that,
Out of that, the
3
ground
soft
floor-
rooms have been gifted to you.
Yes.
So how you are affected?
I am affected in the sense that Nilkanta Shah had parted from this property in 2002, as appears from this gift deed itself. So this suit was instituted in 2023. So Lordship, he has parted long back.
No, sir. Come.
So I should be out of this.
Sir, please come to paragraph 13 of my order. How you are aggrieved, that I want to know.
Injunction respondent from dealing with the property 16 by 1. Yes, so the respondent is not the owner of this portion. He has gifted me in 2002. I am the owner.
He or his wife?
No. He, in this particular matter, the wife is not a party. Lordship will kindly see. The Nilkanta Shah is only there.
I understand.
So I should not be there.
Gift deed was executed by Nilkanta's wife?
Nilkanta's wife in 2023. But in here, Nilkanta's wife is not a party, Lordship. Kindly appreciate.
Sir, I understand.
Yes, Lord.
Try to understand my question.
Yes, yes, my Lord.
Probably I am not clear to you.
I'm trying
You got the property by way of gift from your mother.
Yes, from my mother-in-law.
Mother-in-law?
Yes.
Be that as it may. Lata, that is Mongola Shah.
Mongola Shah is the wife of Nilkanta. That is
Who is the wife of the wife? So how your client is going to be affected?
We got the property from Mongola.
Sir, I understand. You claim that pursuant to the execution of this deed, registered deed of gift,
yes,
you become the owners of the 3 soft rooms.
Yes.
Is this your contention?
Absolutely correct.
Now tell me, reading paragraph number 13, how you are aggrieved. That I want to know.
So my property is coming into their degree holders judgment.
Sir, what injunction order has been passed?
Injunction upon the dealing with the property, premises number 161 by 1 Dokindari Road, ground floor.
The injunction is on the person, not the property.
Yes, I understand, but I have to clarify.
So you do as you like. An injunction order is directed in personam. It's not an injunction in name. It's not that all the inhabitants of Dokindari roads have been injuncted from dealing with that property.
A person has been injuncted who is not the owner. That is the order.
So you deal with the property.
I have clarified that he is not the owner by way of my application.
Asun, take down.
For this application,
no,
this is not blood a meritorious application.
Very good. Let me please listen to my order.
Well, I don't think any
in course of
clarification
his
the name appearing in others also. There are other judgment debtors also in those matters, but similar order can cover them. I'll have similar application also for the maintainability.
তাহলে ওইভাবেই করে
It
দিবি।
can cover.
And Milord, may we file, Milord, we have complied.
হ্যাঁ, এটা রিটার্নেবল করুন ওই আগের যেটা কয় ডেট? হ্যাঁ, 25th।
Milord, the affidavit of service we kept with the customer.
তাহলে একদম উপরে লিখে রাখো, if the affidavit of service as filed today on behalf of the degree holder be taken on record.
Milord, I filed the affidavit of service with respect to the remaining two matters as well.
Yeah.
ওইগুলো সবগুলো তাহলে 2 আর 3 এক হবে। Here there will be there are those are forms, no ki?
Milord, one of them is firm.
Oh,
But Nilkant Shah, Milord, is the
There's a partnership firm.
no, so item number 4 will be absolutely identical.
Yes.
Item number 4,
Yes, Milord.
Nilkanto Saha,
Yes. Yes.
and so far as item number 3 is concerned, what is the relationship between that construction company and the item?
Item 3 is the Priyanti Construction. This is the partnership firm.
Yes.
When my client is the partner. They'll come up with applications and everything. This Nilkanto,
Milord, only
just
judgment debtors.
a minute. Item number 3 টা দাও।
Priyanti and Nilkanto তো আবার আছে।
No, so far item number 4 is concerned, it is same.
Only same, yes. Only
Item number 3 I want.
But item 3 is
আগের অর্ডারটা দিন আমায় দেখি।
Priyanti, Kanta Saha, Mola and Oniti.
Kanta কেন?
No, I want to see the order, which order I have passed.
Nilkanto নেই। ঠিক আছে, Nilkanto, Kanta।
Kantoটাই কান্তাই লিখেंगे। The partners have been made party, so I think they are the wife and son of.
Upon the respondents.
Yes. So only, Milord, the singular word.
Who are the respondents there?
Respondents are three.
Partners of the first firm.
এটা তো এই tabular statement এখানে আছে নাকি?
Or your lordship, Milord, can have a look at the cost statement.
And we'll work it. We'll work on it.
Instead of respondent, we respondents.
Yes.
That is the difference.
The partnership firm and the partners have been made party.
Yes.
We'll meet the point.
512টাই গো।
12টাই হচ্ছে 3।
512 of 2020.
12টাই হচ্ছে 3।
হ্যাঁ 12টাই 512টাই 3।
512টাই 3।
512টা। ও আচ্ছা দাও। ও নীলকণ্ঠ সাহা, মঙ্গলা সাহা and অনিন্দ্য সাহা।
Yes, yes, madam. So, Milord, the restraint order was with respect to all these three individuals who are partners of respondent number 1.
এই এদিকে এসো দেখো।
Restraint order is prospective.
সেটি কোথায় গেল? যে রেকর্ডিং অফিসার ওখানে ওই জায়গাটা আমরা কি বলেছিলাম একটু বলো তো। ওই আমি এটা বললাম না ইন্টারভেনার ক্ষেত্রে
সব বুঝি আমি। হ্যাঁ বুঝি। আমরা বুঝি। Restraint order is prospective.
হ্যাঁ আরো নিচে যাও, আরো নিচে যাও। হ্যাঁ হ্যাঁ রেসপন্ডেন্টস জাজমেন্ট ডেটার্স ওইখানে লিখে নাও রেসপন্ডেন্ট জাজমেন্ট ডেটার্স। হ্যাঁ তারপরে কি লিখেছি না রেসপন্ডেন্ট জাজমেন্ট ডেটার্স
the interim order is brought till disposal of the instant execution case or till further order. So, I hope that it is understood that the interim order of injunction is continuing. Because today
So that is your understanding. I'm not here to interpret.
No, then it's a lordship order. I hope that is not necessary for any extension because it is there till the.
Yeah, you are more intelligent than me. I believe.
No,
the
sometimes
next-
we bounce back.
No extension is continue.
The next date may I?
Yes, the lordship has not fixed the date.
Date. Maybe I.
সব শেষ হয়ে গেল, হ্যাঁ। এই ডেটটা কবে দিন হবে?
Can it be on the
25th. April 25.
25th. 25th. No, 25th of April. April. তাই বলো, তাই ঠিক আছে।
Yes.
25th of April. My lord. Second half তো হয়।
Call the next matter.
Obligement.
Deep love.
My lord, in item number 5, I am for the decree holder, my lord. My lord, on the last occasion, my lord had directed us to file an appropriate application for amendment, my lord. The application is ready, my lord. However, my lord, it is yet to be settled, my lord. I'm praying for a week's time, my lord, to file the
Not
application.
But this is my application. I am for the degree holder, my lord. The decree was passed, my lord, for rupees 36 lakhs 10,000. Our respondent is my lord Senko Jewelers. Well, at this stage, my lord, I am only praying for the directors should file their affidavit of assets and one property, my lord, I got, my lord, in their name. Kindly see, my lord.
কোনো অর্ডার হয়েছে না ফার্স্ট ডেট?
Page 7, my lord. Page 7.
Give me a second, sir. Is a money degree?
Money degree, my lord. Money degree.
Have you annexed the certified copy of the degree?
Yes, my lord. I have annexed, my lord.
What is that, sir?
Yes, my lord. It is annexed in the page 10, my lord. Page 10, my lord. And the type of, my lord, the order is at
To pay to the plaintiff, petitioner Ashok Jaria, his sum of due is 28 lakh 80,000.
yes, my lord. Page 21, my lord, the order clearly written, my lord. Page 21. In view of the defendant is directed to pay sum of 28 lakhs 80,000 with the rate of 18% interest, and the court further imposed a cost of rupees 1 lakh.
It is a expiry degree?
Yes, my lord, I have exported it. It was under order 13A, my lord, of Commercial Court Act, my lord.
Oh.
We admitted claim, my lord, check was bounced, and thereafter he has issued a letter.
What do you want now?
Well, at this stage, my lord, I want only prayer in terms of prayer D, my lord. Let the direction be given to the judgment debtor in directors to file their affidavit of assets, and my lord, restraining them to sell one property, my lord, which is my lord at page 7, paragraph 13, A1.
Page 7?
Page 7, paragraph 13. They are holding various properties, my lord, but with regard to property number 1, my lord, at 168 BB Ganguly Street, they are running with this soap, my lord. Kindly see the page. I have annexed one photograph, my lord. Kindly see page 26, my lord. They are running this soap from BB Ganguly Street, my lord, and the transaction took place here, my lord. The goods were supplied at this address.
In course
Your Lordship, with your permission, I would appear online if your Lordship
My lord,
permits.
this is my application for execution of a decree.
Judgment letter is appearing.
I am the caveator judgment debtor, your Lordship.
Lordship,
But number
I'm the
one.
judgment debtor number 2.
Kunanagal. বইটা দেখি CPC টা দেখি তো।
My lord, this is within 2 years. The decree was passed in April 2024.
No, when they have appeared, 2 years, 3 years gone, all gone.
Yes, but there's only one caveat and we had served.
Lordship, the judgment debtor number 2 has not been served.
And your Lordship, both judgment debtor 1, respondent 1, and respondent 2 have filed appeals as well, which has not
Appeals are
actually been
pending,
recorded.
My lord,
in
there is no stay. The order passed, the appeal was admitted, order passed with a conditional order was passed, directing them to furnish the security, which they have failed to do so.
Your Lordship, we had
There is
actually.
no stay.
Your Lordship, we were willing to furnish the decretal amount.
Your,
And for that reason, we wanted to file an extension so that
My
we
lord, since 11 September, there are
your
orders.
Lordship, for
judgment debtor number 2, your
You
Lordship.
are appearing on behalf of?
judgment debtor number 1, your Lordship, Amazon Seller Services Private Limited.
I'm appearing for Kunanagal. Judgment debtor number 2.
Who is the judgment number 2, sir? Madam?
Yes, we are.
Kunanagal.
No, no, who?
Kunanagal Private Limited.
What is the certified copy of the judgment degree?
40.
Page 40, Mali.
40?
Starts at page 40. My lord, the ordering portion is at page 44.
OCD 7.
Degree the defendants do jointly and severally pay sound of his 30. This is a money decree.
It's a money decree. My lord, they have preferred appeal. The admitted position today is that since September, orders were passed directing them to put in the security. Till date, they have failed, and there is a clause in the last order passed by the appeal court that in the event they fail to furnish the security, the decree will be executable. Now, today, your Lordship has to pass an order for directing the defendants to file the judgment debtors to file their affidavit of assets.
Your Lordship, there
my
is a
learned
difference here.
not object
If
to
I
that.
may, your Lordship, as for judgment debtor number 1, we filed an appeal. The order was passed by the appellate court, division bench led by Justice Soumitra Sen on 12th of February, directing us to file the security amount. Your Lordship, we have got the demand draft with us. We had got the demand draft there as well before the court, but because Amazon Seller Services head office is in Bangalore, while the finance department sits out of Delhi, it took a little while for coordination. The demand draft was prepared and sent across to Calcutta before the court, and it was ready on 28th of February, your Lordship. When we mentioned the matter before the division bench,
can you show a copy of the demand draft?
Yes, your Lordship. My associate before the court has it in front as well. Your Lordship, when we mentioned the matter before Justice Soumitra Sen, he directed us to file an application. Unfortunately, after our application has been filed for, I think it was served on the other side as well. The application has not been received because
they have made it ready.
Lordship, we are also ready. Your Lordship, our office is also in Delhi, Your Lordship.
Submission,
And we also have, we are also ready to pay it, Your Lordship. Your Lordship will kindly grant us some time, Your Lordship.
Your Lordship, if your Lordship gives us 4 to 6 weeks, we'll
Absolutely, Your Lordship. Both the judgment debtors are ready. Both have their offices outside of Calcutta.
Take down.
My lord, your Lordship will hear me out and then
how do you?
No, my lord. Subsequently, what has been submitted to your Lordship, my lord, the order dated 12th of February gave them a time period of 2 weeks.
You are making submission in here. Where are those orders?
That order is annexed, my lord. I was not allowed to place that order. It is at page 71.
71 কি করেছে?
The time expired on 26th of February.
Sir,
They cannot
Lordship
Sir,
is ready and willing to
I'm
pay.
asking one thing. Can I take up this matter? Because I'm a part of the division bench.
Because your lordship, there is no. I'm sorry, with leave of my learned senior.
Huh.
Your lordship, there is no clash of interest so far as lordship being a part of the.
No, probably it cannot be taken up by me. Because I'm a part of the division bench of that.
But
Yes,
It's only in one order where your lordship has been a part of one of the division bench. But there's.
Well, there are previous orders also. If your lordship will come to page 57. This point was not taken up by my learned friend. They were aware of this order.
Matter is released from
This
matter is released on my personal ground.
This is not an appeal.
The lordship
Liberty is given to the degree holder to approach the Honorable the Chief Justice.
Your Lordship will kindly record in the meantime if the
this
if the
court
judgment
cannot
letters
give that liberty to my learned friend because
in
that
the
is an
meantime
order
if the judgment
passed
letters
by the appeal court. The appeal court has
given liberty to approach.
Yes, I'm deeply obliged, Your Lordship.
Oblige, Your Lordship.
Honda.
Side copy of the order, that's
No. It is released on my personal account.
Okay.